We always said that Donald Trump would be his own undoing, and that his own bad conduct, misconduct, attacking of witnesses, attacking of the judge, attacking of prosecutors would ultimately be considered during sentencing, and how right we were. We've got a new filing by the Manhattan DA to try to keep their conviction, hard-earned conviction that they obtained on 34 felony counts against Donald Trump intact, to have the judge either sentence Donald Trump before January 20th's inauguration, or keep the conviction on the books and sentence him 4 years hence after he comes out of office when his temporary immunity evaporates. There's a huge section in the 86-page brief in which the prosecutors recount for the judge, who I'm sure knows it well, all the ways that Donald Trump abused the process, abused the prosecutors, abused the court system, abused the judges over and over again, which is a factor as to whether he should have his motion to dismiss on justice purposes granted or not. Confused? You won't be when I'm done with this hot take on Legal AF, the YouTube channel. I'm Michael Popok. Let me break it down for you as a practicing lawyer in New York. How we got here is Donald Trump filed about a week ago a motion to dismiss his conviction. No other way to put it. Not the indictment. The indictment has been converted into a conviction. He wanted to get rid of his conviction because he won the presidency, because he's the president-elect now. And, well, not technically. He will be on Jan 6th. And he will be the president on Jan 20. And therefore, everything that happened before, even before he was president, should just miraculously disappear like a magic etch-a-sketch. Just shake it, gone. Conviction's gone. Judgments, $500 million judgments against him, gone. All because he won. That's not how that works. That wasn't in the job description for the president when he ran, and that's not what the American people voted for. So he filed his motion. The judge allowed him, and the judge has been holding in abeyance two things. One, he's been holding when he's going to sentence Donald Trump for the 34 felony count convictions to that year or two in prison. He's delayed that decision for a bit. And he's also delayed, Judge Merchan has delayed the decision on whether the immunity ruling by the Supreme Court back in July affects these decisions or not, and should lead to the dismissal of the case. And I believe his ruling has already been made, and the answer to that is no. Nothing about the immunity decision. Now you're left with this last-ditch effort by Donald Trump to file a paper under a certain provision of the criminal process rules in New York, and under CPL 210, which says that under a certain factor analysis, the Clayton factors, we call them in New York, there's about 7 or 8 of them, whether in the interest of justice, a conviction should be overturned. There's nothing in what Donald Trump provided in terms of a rehash, old leftovers of arguments he's raised and been rejected by appellate courts and trial judges before that would lead to the conclusion that he's satisfied any of those factors. But it required the Manhattan DA to go through each of these factors one by one by one, methodically. And that's why we get to the section I'll go over in a minute. I'll read to you from in a minute, in which they go over all the bad ways that Donald Trump abused the process. Their fundamental arguments are the following, that this is for the prosecutors, that there is no such thing as president-elect immunity under Article 2 of the Constitution, so reject that completely. There's no reason Donald Trump can't be sentenced from now until January 20th when he takes office. The only and it could happen. The judge could do that. Of course, there's whatever he rules in the remaining month and a half is going to be taken up on appeal. That'll delay the sentencing. And we're now into the world of President Trump, unfortunately. And then, so their argument is there's nothing in the case law. There's nothing in the Constitution. There's nothing in the Office of Legal Counsel at the Department of Justice, which is not binding on them because they're a state prosecutor, but it's out there, that would preclude the ability to continue to a sentencing of a previous conviction of a person who now occupies the office of the presidency. But even if you don't like that, the Manhattan DA says to the judge, look, whatever his immunity status is, we could sit here and debate it all day long, when he takes office, it's temporary. It evaporates in 4 years. So you can do one of two things, they say to the judge. You can delay the sentencing. You can terminate these proceedings for now. Keep the conviction on the books because a jury of 12 people worked hard in the interest of public justice to rule on that. Keep that on the books. Make a note that the case is being terminated only for a short period of time, and we'll pick back up with it in 4 years for sentencing. Could do that. Or you could sentence him now, or even when he first takes office. but suspend the sentence, abate the sentence until he leaves. Make it a condition of the sentence that he serve out his term as president and return to being John Doe, so to speak, and then the sentence starts. Could do that. And I mean, against the argument that Trump has raised, oh, that'll put a shadow over the president. That'll make him subject to public scorn and disdain. Well, that has already happened. Right? There's nothing you can do about it. He's already been convicted. There's nothing, they can't wipe the slate clean. So they're saying that by sentencing him and making him start the sentence 4 years from now, so what? It doesn't undermine the office of the presidency, or keep the conviction on the books, and we'll see everybody 4 years hence. They also cite, I think properly, the Sixth Amendment, which requires speedy trial, including speedy sentencing, that public justice requires and demands that the sentence be imposed, even if delayed, so that the public knows. And a 2-year, 3-year, or 4-year delay is not a problem. They also cite, the Manhattan DA, a doctrine that talks about abatement in case of death. No, they're not suggesting that Donald Trump should die, but they are saying that there is a doctrine or a equitable principle in the criminal law in New York, which says that if somebody was convicted of a crime and dies before sentencing, there's a way to handle that. You abate the proceedings. It doesn't change the conviction, but you make a note that the sentencing hasn't happened yet. So there's a number of ways, and I think what the Manhattan DA is trying to say is what we anticipated on Legal AF, the podcast, that they would say time heals all wounds, and time eventually solves the problem of this conundrum that we seem to be in about the application of presidential immunity. Even if it were to apply, it doesn't apply forever. And it certainly doesn't give grounds or a right to somebody to say, jackpot, I won the presidency. Vacate and throw out my conviction. That's not the prize that you won. You won the prize of being president for 4 more years with all the trappings of that office. So here's the part which I'll read to you from, in which they go over how many times Donald Trump has violated and gone after and attacked these proceedings. So this is on starts around page 48. Talks about the history, character, and condition of the defendant. That's one of the factors to be analyzed for this particular motion. And what they say is the court previously reviewed the extensive evidence of defendants, that's Trump's, threatening, inflammatory, and denigrating public attacks on local federal officials, court and court staff, prosecutors, and staff assigned to the cases, and private individuals, including grand jurors, performing their civic duties, and the consequences of that. They go on to say, in a subsequent opinion, the court further noted that Trump's pattern of attacking family members of presiding jurists and attorneys assigned to his cases serves no legitimate purpose, and instead injects fear in those assigned or called to participate in these proceedings. Defendant, this is on page 49, Defendant Trump has engaged in multiple such attacks in these criminal proceedings before, during, and after the trial. While the grand jury was hearing evidence, he began making a series of comments on social media, attacking the anticipated charges and making threats, including against the district attorney. He threatened death and destruction if he was indicted, and posted a photo of himself holding a baseball bat at the back of the district attorney's head. He made other statements about the district attorney, that's Alvin Bragg, being an animal, a degenerate psychopath, human scum, calling prosecutors animals and thugs, referring to multiple witnesses in pejorative and violent terms, threatening years of hatred and chaos and turmoil if he was indicted. And they go on. As we said before, Donald Trump needed to be careful, but he wasn't, about what he did and how he acted within the confines of the criminal justice system, because it would come back to bite him. Right now, we're in the biting stage. They go on page 50 to say, Trump's language is often ominous and violent. He referred to one potential trial witness as death just weeks before the trial was scheduled to start. Following these attacks, there have been numerous credible threats of violence, harassment, and intimidation directed at witnesses, the court, the district attorney, the family members, and employees of the district attorney's offices. In addition, defendant willfully violated the court's orders on extrajudicial speech multiple times. That's the gag order, over and over and over again. They go on page 51 to talk about Trump's history of threatening witnesses and investigators, prosecutors, judges, jurors, court staff, and their family members in detail with citations. No, they don't mention the Midas Touch Network, Legal AF, or Michael Popok, but they do go over ad nauseum all of the attacks by Donald Trump and the history of malicious conduct by Donald Trump. And the reason they're bringing this up is because it's a factor that needs to be analyzed by the judge in whether to grant the motion to dismiss on justice grounds. So here's the summary, right? To wrap it up here. They are not going to agree to vacate the sentence. The conviction stands. The judge now is not going to take any more papers in. He said 2 briefs. I'm sure Donald Trump is a pig, so his lawyers are going to try to ask for another brief, even though it was clear that the judge only wanted 2 briefs, this being the final word, the one for the Manhattan DA's office. Let's assume the judge rejects or gives a short reply, even though he said he didn't want one, of 4 or 5 pages. In the next couple of weeks, the judge is going to have to decide, still in the month of December, whether he's going to sentence Donald Trump before January, rejecting the argument that there is a president-elect immunity. I think he may try to do that. It would go up to the appellate court. It'd get tied up in the appellate court. By that time, it become moot because Donald Trump would become president. Then the question is, when this finally, after appeal, gets returned to Merchan, what will he do with it after Donald Trump is president? I think he delays the sentencing 4 years and does the sentencing at that time. He could, however, sentence Donald Trump now, but suspend or abate the sentence until after his presidency is over. So we got a lot of moving parts here. I'll leave it with this. Does Merchan sentence now and have it start later? Not sentence now, but wait for the appellate process and then sentence, or defer the sentence? And when would Donald Trump go to jail? The reality is, to be frank, let me just turn off my phone here. The reality is that Donald Trump is not going to serve any jail time during this particular, let me start over again. The reality is that Donald Trump is not going to serve any jail time while he's in office, but could likely serve jail time upon his return to civilian life, if you will, at the end of his presidency. I'll continue to follow it here on Legal AF, the full-length podcast, and on a new show on Tuesday nights at 8 p.m. on the Midas Touch Network I do called Popok Live at the intersection of law and politics. So until my next reporting and analysis about all things Legal AF, I'm Michael Popok. In collaboration with the Midas Touch Network, we just launched the Legal AF YouTube channel. Help us build this pro-democracy channel where I'll be curating the top stories at the intersection of law and politics. Go to YouTube now and free subscribe at Legal AF MTN. That's at Legal AF MTN.